If you're a green card holder in the United States right now, you need to hear this. Something just changed that has thousands of lawful permanent residents completely shocked, and many don't even know about it yet. What happened? Why are immigration attorneys suddenly getting flooded with calls? And could this affect your status, your travel plans, or even your path to citizenship? Stay with me, because what I'm about to share could be the difference between keeping your green card secure and facing serious complications you never saw coming. This isn't about panic. This is about being informed, being prepared, and understanding exactly what's happening right now in U.S. immigration policy. Let's get into it. Welcome back to the channel. Today, we're breaking down a critical development that directly impacts millions of green card holders across the United States. This video is about green card holders shocked new U.S. immigration law just changed everything. And yes, I'm going to explain exactly what changed, who's affected, and most importantly, what you need to do right now to protect your status. This video is for you if you're a lawful permanent resident, if you're about to receive your green card, if you're supporting family members with green cards, or if you're simply trying to understand the shifting landscape of U.S. immigration in 2025 and beyond. Whether you got your green card through family sponsorship, employment, the diversity lottery, or any other pathway, these changes matter to you. Here's what we're covering today: the specific policy updates that just took effect, who is most at risk, the shocking scenarios that are catching people off guard, what you should do immediately, and how to separate fact from the viral misinformation spreading across social media right now. This is not legal advice. I'm a journalist bringing you the facts. But by the end of this video, you'll have the clearest picture of what's really happening and what steps legal experts recommend you consider. Let's dive in. What changed in the new law? So what exactly changed? According to official policy updates from the Department of Homeland Security and U.S. Citizenship and Immigration Services, there have been significant adjustments to how green card status is monitored, how violations are enforced, and what triggers a review of lawful permanent residency. First, let's talk about enhanced monitoring systems. Immigration authorities have implemented upgraded technological infrastructure that cross-references databases more efficiently than ever before. This means that activities like international travel, employment verification, address changes, and even certain financial transactions are now being tracked with greater precision. The system flags inconsistencies faster, which can lead to quicker scrutiny of your permanent resident status. Second, there's been a tightening of the rules around what's called abandonment of residency. For years, green card holders understood that extended time outside the United States could jeopardize their status. The general guideline was that trips lasting more than 6 months might raise questions, and trips over 1 year would almost certainly require a reentry permit or could be considered abandonment. What's changed now is how aggressively these rules are being enforced at ports of entry. According to currently available government guidance, Customs and Border Protection officers have received updated training and protocols. They're asking more detailed questions, requesting more documentation, and in some cases referring green card holders to secondary inspection even when their travel seemed routine. The threshold for what triggers additional scrutiny appears to have lowered. Third, there's increased attention to conditional green cards, those issued to individuals who obtained permanent residency through marriage to a U.S. citizen when the marriage was less than 2 years old or through certain investment programs. The process of removing conditions, which requires filing Form I-751 or I-829, is now subject to more rigorous verification. Processing times have increased, interviews are being scheduled more frequently, and the burden of proof has intensified. Fourth, public benefit usage is under closer examination. While the public charge rule has gone through various changes over recent years, current enforcement emphasizes reviewing whether green card holders have accessed certain public benefits in ways that could be deemed inconsistent with their status obligations. This doesn't mean you can't ever use benefits you're legally entitled to, but it does mean that patterns of dependency could potentially be flagged during renewal or naturalization processes. Let me give you a real-world example to illustrate how this works. Imagine someone we'll call Maria. Maria received her green card through marriage 3 years ago. She's been living in the United States, working part-time, and everything seemed fine. Last year, she took a 5-month trip to care for her sick mother overseas. When she returned, she was pulled into secondary inspection for the first time ever. Officers questioned her extensively about her ties to the United States, her job, her residence, her tax filings, even her bank accounts. Though she was eventually admitted, she was warned that future extended absences could result in her being considered to have abandoned her permanent residency. This is the new reality. Who is most affected? Not every green card holder faces the same level of risk from these changes. Let's break down who needs to pay the closest attention. Family-based green card holders, particularly those with conditional status, are facing heightened scrutiny. If you received your green card through marriage and you're approaching the 2-year mark when you need to file to remove conditions, understand that USCIS is conducting more thorough examinations of these relationships. They're looking for evidence that the marriage is genuine and ongoing. Joint financial documents, shared leases, photos together, testimony from friends and family. All of this matters more than ever. Employment-based green card holders need to be aware of changes in job portability rules and how employment gaps are viewed. While you're not permanently tied to the employer who sponsored you once you have your green card, authorities are watching whether you remain employed in your field and whether your economic activity aligns with the basis on which you receive permanent residency. Extended unemployment, especially without clear justification, can raise red flags. Recent arrivals, those who received green cards within the past 3 years, are under more intense observation. This makes sense from an enforcement perspective. Authorities want to ensure that the status wasn't obtained fraudulently and that recipients are genuinely establishing their lives in the United States. If you're in this category, maintaining clear documentation of your U.S. ties is essential. Long-term residents who have had green cards for many years but haven't naturalized are also seeing changes, particularly around travel. Even if you've had your green card for 15 or 20 years, extended absences can now trigger questions about whether you've truly maintained U.S. residency as your permanent home. The assumption that long-time green card holders would automatically be waved through is no longer reliable. Green card holders from specific countries that have complicated diplomatic relationships with the United States or that are subject to special monitoring programs may experience additional layers of review. While immigration law is supposed to be applied uniformly, practical enforcement sometimes reflects geopolitical realities. Shocking scenarios. Let me walk you through some scenarios that immigration attorneys are seeing more frequently, not to scare you, but to educate you about what can go wrong and how to avoid these situations. Scenario 1. A frequent traveler. Consider someone who travels internationally for work every few months, sometimes staying abroad for several weeks at a time. Each individual trip is under 6 months. So, they assume they're fine. But what they don't realize is that the cumulative pattern of spending more time outside the United States than inside it can be interpreted as evidence that the U.S. is not actually their permanent home. When questioned at the border, they struggle to demonstrate strong continuing ties. This can lead to their green card being challenged, even confiscated in extreme cases. Scenario 2. The address update failure. Immigration law requires green card holders to report address changes to USCIS within 10 days of moving. Many people don't know this rule or forget to comply when their green card comes up for renewal or when they apply for naturalization. This failure to update addresses can be used as evidence of not following the law. In some cases, it's even been grounds for denying naturalization applications. Scenario 3. The tax filing gap. There's someone who lived in the U.S. for several years with their green card, then spent 18 months abroad for family reasons. During that time abroad, they didn't file U.S. tax returns, assuming that since they weren't in the country, they didn't need to. This is a critical mistake. Green card holders are required to file U.S. taxes on worldwide income regardless of where they live. The IRS and USCIS do share information, and unexplained gaps in tax filing can seriously damage your immigration case. Scenario 4. The conditional green card deadline miss. A couple received their conditional green card and knew they had to file Form I-751 to remove conditions. Life got busy. They procrastinated and they missed the 90-day window before their card expired. Their status automatically terminated. Now they're out of status. They can be placed in removal proceedings, and fixing this mistake requires extensive legal help and isn't guaranteed to succeed. Scenario 5. The misunderstood benefit. Someone with a green card applied for and received certain public benefits during a period of genuine need, maybe unemployment assistance or Medicaid. They were legally entitled to these benefits. However, They didn't realize that extensive use of these programs could later be scrutinized when they applied for naturalization. When they filed their N-400 citizenship application, officers asked detailed questions about their benefit usage and whether they were truly self-sufficient. These scenarios aren't meant to frighten anyone. They're meant to show you that small misunderstandings or overlooked requirements can have significant consequences under the current enforcement environment. What green card holders should do now. So, what should you actually do right now to protect your status? Let me give you clear, actionable steps that legal experts commonly recommend. Step 1. Review all your documents. Pull out your green card and check the expiration date. Conditional green cards expire after 2 years. 10-year green cards expire after, 10 years. Mark your calendar for 90 days before expiration and set reminders to start the renewal or condition removal process. Don't wait until the last minute. Step 2. Verify that USCIS has your current address. Log into your USCIS online account if you have one or contact them directly to confirm. If you've moved and haven't updated your address, do it immediately. You can file Form AR-11 online for free. Step 3. Gather evidence of your ongoing ties to the United States. This includes leases or mortgage documents, utility bills in your name, employment records, tax returns for every year you've had your green card, bank statements showing U.S. accounts, memberships, and U.S. organizations, children's school enrollment records, anything that demonstrates this is genuinely your permanent home. Step 4. If you travel internationally, document everything. Keep records of when you leave and when you return. If you're planning an extended trip, consider whether you need a re-entry permit. If you're gone more than 6 months, be prepared to explain at the border why you were away and show evidence of your intent to maintain U.S. residency. Step 5. Stay current on all tax obligations. File your federal and state tax returns every year on time. If you've missed years, work with a tax professional to get caught up. The intersection of immigration and tax compliance is increasingly important. Step 6. If you have any questions about whether your situation is complicated, if you've traveled extensively, if you've had employment gaps, if you've received public benefits, if you're approaching naturalization, if anything feels uncertain, consult with a qualified immigration attorney. Not every case needs a lawyer, but many more cases would benefit from professional guidance than actually get it. A consultation can identify issues before they become crises. Step 7. If you're on a conditional green card, start preparing your I-751 petition months in advance. Don't wait until the last minute. Gather your evidence of genuine marriage or genuine investments systematically. The stronger your package, the less likely you'll face an interview or denial. Common myths versus reality. There's a lot of misinformation circulating on social media, in community groups, and even among well-meaning friends and family. Let's clear up some of the most damaging myths right now. Myth number 1. Once you have a green card, you can live anywhere and it can't be taken away. Reality. Your green card represents permanent residency in the United States. The key word is residency. If you establish your primary residence outside the U.S., you can be found to have abandoned your status. The card itself doesn't guarantee anything if you're not actually residing permanently in America. Myth number 2. You can stay outside the U.S. for up to 1 year with no problems. Reality. While it's true that absences under 6 months are generally safer, and absences over 1 year almost certainly require a re-entry permit, every extended absence can be questioned. There's no magic safe period. Officers are trained to look at the totality of circumstances. Myth number 3. If you've had your green card for a long time, these new rules don't apply to you. Reality. These enforcement changes apply to all lawful permanent residents, regardless of how long you've had your status. In some ways, long-term residents who haven't naturalized face additional questions about why they haven't taken that step. Myth number 4. You don't need to file taxes if you don't earn much money. Reality filing requirements are based on specific income thresholds, but even if you don't owe taxes, you may still need to file a return. More importantly, having a record of consistent filing is crucial for immigration purposes. Myth number 5. Renewal is automatic and simple. Reality. While many green card renewals are straightforward, the process still requires completing forms correctly, paying fees, providing photographs and documents, and potentially attending biometrics appointments. Mistakes or delays can cause serious complications. Myth number 6. Using any public benefit will disqualify you from naturalization. Reality: not all public benefit usage creates problems. Many benefits are specifically exempt from public charge considerations. However, heavy reliance on certain cash assistance programs can potentially raise questions about self-sufficiency. The key is understanding which benefits might be scrutinized and maintaining overall financial independence where possible. Myth number 7. These changes are part of a secret crackdown not officially announced. Reality: while enforcement priorities do shift, the fundamental laws and regulations governing green cards are publicly available. What has changed is the intensity and technology of enforcement, not the underlying legal framework. Expert Insight Style Section. Immigration attorneys across the country are seeing similar patterns in their practices right now. They're emphasizing to clients that the margin for error has narrowed significantly. Small compliance issues that might have been overlooked in previous years are now being caught and questioned. Legal experts explain that much of what's happening isn't actually new law. It's stricter enforcement of existing law. The requirements around maintaining residency, filing address changes, paying taxes, and removing conditional status have been in place for years or even decades. What's different is the systematic technology-enabled approach to catching violations. Former USCIS officers note that the agency has been under political pressure from multiple directions over recent years. Pressure to both process applications more efficiently and to ensure that status isn't being abused. The result has been investment in database systems, officer training, and interagency cooperation that makes it much harder for things to slip through the cracks. Immigration policy analysts point out that these changes reflect a broader trend toward what's sometimes called enforcement through attrition, making the system more complicated and risky so that people select out or are caught in technical violations rather than through mass deportation operations. For green card holders, this means that maintaining status requires more active attention and documentation than it used to. Attorneys also stress that these developments make the pathway to citizenship more important than ever. Naturalized U.S. citizens have protections that green card holders don't. While naturalization has its own requirements and complexities for those who qualify, it eliminates most of the vulnerabilities we've discussed today. Future outlook. Looking ahead to the rest of 2025 and into 2026, what should green card holders be watching for? Several trends are likely to continue or accelerate. First, expect technology to play an even bigger role. Biometric tracking, database integration, and potentially even social media monitoring may become more sophisticated. The days of immigration being a paper-based system with limited interagency communication are over. Second, watch for potential legislative changes. Congress has debated comprehensive immigration reform for years without success, but smaller targeted bills affecting green card holders could pass. These might address issues like conditional residency requirements, public charge rules, or expedited pathways to citizenship for certain categories. Third, enforcement priorities will likely continue to reflect the political climate. Different administrations have different philosophies about immigration enforcement, and these philosophies filter down to how individual cases are handled. Stay informed about policy announcements from DHS and USCIS. Fourth, processing times and backlogs will remain a challenge despite efforts to improve efficiency. The immigration system is handling enormous volume with limited resources. Plan ahead, file early, and be prepared for delays. Fifth, the intersection of immigration status and other areas of law, taxes, criminal justice, employment law, family law will become increasingly important. Green card holders need to understand how decisions in one area of their life can affect their immigration status. What you should monitor: official announcements on the USCIS website, policy memoranda from DHS, updates to the Foreign Affairs Manual that governs consular processing, and credible immigration law newsletters or news sources. Be cautious about getting information from social media or non-expert sources. Understanding the difference between legislative changes, which require Congress, and executive policy changes, which can happen through agency action, is also important. Many of the developments we've discussed today fall into the executive policy category, meaning they can shift with changes in administration priorities. Strong outro and call to action. We've covered a lot of ground today, and I want to make sure you're leaving this video with clarity, not fear. Green card holders shocked. New U.S. immigration law just changed everything, but knowledge is power. And now you have the information you need to navigate these changes successfully. Here's what I want you to remember. Your green card is valuable, but it's not a set it and forget it document. It comes with responsibilities. Maintaining residency, following rules, staying compliant with tax and address requirements, and understanding the conditions of your status. The enforcement environment has tightened, which means mistakes that might have been forgiven before can now have serious consequences. But here's the good news. If you stay informed, stay organized, keep good records, and seek professional help when you need it, you can protect your status and work toward naturalization if that's your goal. Most green card holders who are following the rules and maintaining genuine U.S. residency will navigate these changes just fine. If this video helped you understand what's happening and what you need to do, please hit that like button right now. It helps us reach more people in the immigrant community who need this information. Subscribe to the channel and turn on notifications so you don't miss future updates on immigration policy, because this is definitely an evolving situation and I'll be keeping you informed every step of the way. Share this video with any friends, family members, or community members who hold green cards. This information could make a real difference in someone's life. And the more people who understand their rights and responsibilities, the stronger our community becomes. Remember, the goal here isn't panic. It's preparation. It's not fear. It's facts. You have what you need to make informed decisions about your immigration status and your future in the United States. If you have questions, or if there are specific immigration topics you want me to cover in future videos, drop them in the comments below. I read every single one, and your input helps shape the content on this channel.